My name is Pat Foster, and I have been in private practice as a certified public accountant for over 40 years. I am the editor and founder of the West Michigan News Company. On August 23, 2009, I led 4 groups of volunteers out to various townships and city locations in Allegan County, Michigan, to see and photograph the ballots of the 2008 general election. We did this under a Freedom of Information Act request. This endeavor forced Michigan's Attorney General Mike Cox to issue an AG Opinion number 7247 on May 13, 2010, allowing Michigan citizens to see the ballots 30 days after an election has been certified using a FOIA request. We were only the 5th state in our union to allow that. On January 10, 2010, less than 5 months after starting this audit of this election, 2 men, Mr. Benson and his partner, Mr. Klusendorf, signed the closing papers on the house across the street from mine. They later testified under deposition that they came twice regarding this property, and each time they stayed at the Douglas Dunes Motel in Douglas, Michigan. I have friends who work at the Douglas Dunes, and they showed no reservations for them in October through December of 2009. They only had one reservation, which was from January 5th to the 10th. They apparently purchased this house sight unseen. They purchased a parcel of land on a private road that they had no easement to use, which was later proved in civil court. After being very affable to me for a year and a half, they placed metal stakes out into the private road, which was used for over 40 years. In Michigan, a prescriptive easement by adverse possession is only 15 years. To demonstrate to them that what they were doing was injuring all the lot owners who lived on this private road, I placed my truck opposite their stakes and made a stand that if they took out their stakes, I would remove my truck. The Michigan State Police came in request to their call and got us both to agree to remove our items that were blocking the road and not block it until this dispute could be heard in civil court. We both agreed. Mr. Benson later recognized this agreement under oath, qualifying it as a legitimate agreement under the statute of frauds. Mr. Benson's testimony of what was said that day is very different from the video he took that day and gave to us under subpoena. First to the subpoenaed video, then to the courtroom testimony. You decide.
Under Michigan law, I'm saying I don't want to be recorded. And if you continue recording me, you're breaking the law.
You're in private. You're in.
John.
You're in a public road right away.
I didn't record him. I was recording the truck. John, don't say a word.
You have no easement to use it.
Don't say a word.
You have no easement, and I show it right here. So
Don't say anything, John.
that's
Nothing.
my property.
Nothing.
That's
Nothing.
your property over
Nothing.
there.
Nothing.
If you want to
Nothing.
get by,
Nothing.
you can pull all these stakes out.
Nothing. Nothing.
You can take that off of the roadway, and you can return the roadway to the way it was.
Nothing. Nothing.
Because that truck is going to stay there. And
Nothing.
no officer in the world can
Nothing.
give me a ticket for parking on my own property by someone who has no standing. You have no standing, gentlemen. You have no easement to use it. So come on. You want to fight? We're fighting. Now it's time to go to court. And if you go to court, you know what's going to happen?
Nothing.
You're going to need to get an easement by necessity. You know how much that's going to cost you? I talked to Karen Wellman. She's a real estate specialist. It's going to cost you around $100,000. So come on, we're fighting. You don't want to talk? You want to do this bullshit?
Okay, now I won't. I wasn't recording him, I was recording his truck. I didn't even know he was there.
The state patrol was there and Ms. Foster had blocked the road. That's when she laid that on us. There was another incident, and I'm not, without consulting my notes, I'm fuzzy from the J's, Your Honor.
Well, explain, tell me what happened in regards to those threats.
When she said that?
Yeah, well, exactly. What did she, is that what she said? What exactly happened? When did that occur? Was it before the police came, after the police came? Give me a better understanding of what happened at that point.
That was on the November 26th time frame when the state patrol was there on 2011. That's when I was having my medical issues. That was the time frame in which that occurred. I mean, and this was, she had blocked the road.
Right, I understand all that, but when were the threats made? And what threats were made?
Oh, that particular time, and the other attorney requested that videotape to see it, where as she had left her vehicle in the road, and I was videotaping the vehicle, that's when Ms. Foster came up and said all of those things. That's a direct quote that I have in there.
So the quote is, you want to fight, we'll fight, calling you the effing assholes and saying you'll regret this.
Right.
That's the exact quote of what was said on the date of November 26, 2011.
That's correct, Your Honor.
Okay. Were there any other threats?
You video recorded the November 26th incident where you referred to as the fight, come on, you want to fight incident. You videotaped that. You provided my office with a copy, correct?
And I don't know that it went to the court as well, but you asked for it, so it went
Right.
to you.
So that's something that video will speak for itself, so we can simply just make that available to the court, correct?
I don't know.
All right. But I'm just asking you, sir.
Okay.
The fight, you want to fight testimony, or come on, we're fighting, that you videotaped that, correct?
I was videotaping the truck. That happened to show up.
Okay,
The answer is yes.
captured on videotape, right?
Yes.
Okay. And it was clear that Mr. or Mrs. Foster was talking about litigation. She said she referred to a real estate specialist, and it cost you $100,000 to go to court to fight this issue out.
If that's what she said, I don't know.
Objection. He doesn't know what was clear, what she meant.
Well, Your Honor, if I may respond, he's misleading the court. He's making it sound as though he was physically threatened when it's very clear, and he knows it's very clear, that this videotape takes this conversation, takes an isolated portion of the conversation, he gives it to the court to make it sound as though he was physically threatened.
Well,
It's inaccurate, it's misleading.
Well, I haven't seen the video.
Okay, well, I think
And I think you can obviously ask him what was said or not said on the video. And I'd like you to let me finish talking, if you would. And so I think that he can describe what happened that day, and he can describe how it made him feel as far as being threatened, harassed, and he can describe as to whether or not he thought it was physical, emotional, or a lawsuit intervention, or a threat of a lawsuit. I'm not sure that those are necessarily, any one of those things could or could not be stalking, depending on the characterization of it, when it happened, what occurred, and the other things that are going on. So I don't think that the way you phrased it seems to import that there can only be one purpose of this language. And that's what I'm having trouble with in regards to the way you phrased your question.
Do you recall in the same conversation that you were having with Pat Foster, the mention of a real estate specialist and $100,000 in litigation costs? Do you remember that?
I don't recall that.
So when you put that quote in your petition for personal protection order, were you intending for the court to take that as you felt physically threatened, like physical fight?
If somebody is blocking the
I
road
asked you a question.
and I can't leave, and I've got under medical help, I can't get out, and somebody says you want to fight,
Mr. Benson, hold on.
I'm sorry, Your Honor. It was an extensive evaluation, and when they concluded the evaluation, they said, my heart appeared to be in reasonably good shape.
Thank you.
The transcripts of a DVD that was subpoenaed from Mr. Benson that shows that under direct questioning by the court, he lied 3 times.
And I'm not sure what you're asking of the court as far as whether or not perjury charges would be pursued. The court has nothing to do with that. That's a discretion of the prosecuting attorney's office as to whether or not they charge someone with perjury. It's not something the court gets involved in unless it becomes a charged case that gets presented to the court through the process of the criminal justice system.
How does it get to the prosecutor's office if
The police make recommendations to the prosecutor's office in regards to requests for warrants.
So the police have to submit that to the prosecutor's office? Okay. Resubmit it to the sheriff's department. Thank you.